Thank you for coming over here.
Thank you. I'm glad Nicole was available, and nice we can get on again.
Okay. All right, Susan, since we've gathered last, tell us what you've been up to, and tell us what, if anything, you've been doing to prepare yourself to assume the role of a circuit court judge.
I'm still in the same position I was last when I interviewed. I'm full-time family mediator for the 7th Judicial Circuit, and in that role, I stay up on the case law, but also with my membership of other bars, and stay up on case law in criminal area as well as the family. Meeting with the pro se litigants it really keeps me in touch with the idea that people come to court and want to be heard, and they see that in mediation. They want their statement out, they want to be heard. And I try to maintain that awareness that, I'm going to be looking them in the eye, giving them an opportunity to be heard, and seeing if I can help come up with a resolution for them. So I stay focused on that. I'm still a member of the Family Rules Committee, and my work with Family Rules Committee keeps me focused on those same issues and up to speed. And I think that helps serve, a potential judgeship, being aware of the rules of procedure that you follow, whether it's in family law, criminal law, probate, the rules, they may change subtly, but they change, for a reason. Staying attuned to all of that, helps keep me prepared.
Someone else?
I have a question. I have been getting into family law, willingly or unwillingly, through the elevation of one of my partners to the bench. And you have a reputation for getting things that, sort of working miracles and getting cases to resolve. Can you talk about working with pro se parties and how often people with counsel are able to use you in your office, and kind of the magic of getting parties together?
Yeah, there's magic, and I don't know why it happens, except for hard work. I've reviewed the cases before they come in to have an idea of what we're going to be heading into. And sometimes it'll look exceedingly contentious on paper, but so much time has passed since they filed those pleadings, so by the time they come into the office, they're just in a different emotional state. And sometimes it's the exact opposite. The paperwork looks very simple and not contentious, but those underlying emotions are still there. And I probably have, more of my cases have attorneys than are pro se. Not necessarily always 2 attorneys, but when I keep track of, just looking at a week, there's generally more attorneys involved. And probably the difference I see there, the pro se parties, you'll have a group of them that they're appearing at mediation simply because they're pro se, and they're not far apart. They just don't know what to do, and document prep people aren't getting that done for them. They'll go to them, I'll see them, the document prep notification. I'm not a lawyer, I just help fill out paperwork, but they just didn't get all their I's dotted and T's crossed. And so some of those mediations are relatively simple. It's just trying to get everything done like they're supposed to. And then you'll have the pro se parties who truly are very contentious, and it's trying to get them to focus on the issues that can be solved, and reminding them that the court system can't solve their emotional angst that they're feeling over the breakup. That's just not the role of the court system, but trying to come up with a parenting plan that may help them move forward, and getting them to focus on it. They sometimes realize, if we can get these issues resolved, then we're no longer fighting over them. And so that way we can leave here today and not be arguing over the same things we've been arguing over 6 months. And if they know that, and they're like, okay, wow, this is done, and not having to come to court anymore, we're not going to be arguing over the same stuff, it motivates them to get a resolution. And with counsel, it varies. I'll have cases where it's super contentious, yet again they look at it that it's a time to get everything behind them. And sometimes the parties haven't been super contentious, but the mediation serves the role of everyone is very busy, but you get to the table at the same time, and that means everyone's focused on the issues that day. And it's kind of the point of case management, getting, whether it's the litigants or the attorneys in court, and saying, what is it going to take to get it resolved? Because not only do the attorneys get busy with all their other all their other clients, but their clients themselves get caught up in their own daily life and don't necessarily focus on getting their issue resolved. And so you kind of remind them, whether it's case management or mediation, like, okay, we've got this here today, what can we do to get you resolved today? So you as litigants aren't having to spend your valuable time in court, because that's not where they're wanting to spend their time. They're wanting to spend their time doing their regular jobs and careers and spending time with their family, not in the court system. And so reminding them of that and that opportunity that they possess, if they get a resolution, a lot of them will reach for it.
Let me ask you, you left private practice, your partner, in 2011. What was the reason behind moving from private practice to the mediator role that you now serve in?
Well, I had been a public defender years before and had about 4 years of service in the state. And when I was in private practice, maybe in 2007, I think I became a mediator. But most of my mediations in private practice, I was the attorney representing the party. I did very few roles as the mediator, even though I was certified in the area, because generally if clients were coming in, because I was going to be representing them. And in 2011, the mediator for Volusia County, Suzanne Renaud, retired. And so court administration had kind of, I guess, sent out a notice to certified mediators in the area and said, hey, we're just looking for some contract mediators to fill in over the summer, because I think Ms. Renaud had retired maybe before the end of the budget year, and they weren't certain if they're going to hire another one or this or that. So they just used contract mediators that summer. And our office, like a lot of offices, we primarily did most of our work like Monday to Thursday, and then Friday we tried to do our office work on getting filings done and all that. So when the call went out for a contract mediator, I thought, well, I could use the Fridays and use that, get some mediations in and not interfere with my private practice. And it worked out just fine, and I was not even thinking about becoming a full-time mediator. The position wasn't open, wasn't on my mind. And then a couple months later, they did then advertise for the position, and I don't know, I think they advertised twice, because I wasn't looking for jobs, because I had a job, I wasn't thinking about it. They advertised the second time, like they actually then kind of sent out an email, and again, I don't know if it was to the mediators in there or whatever, but I got that, and I thought, just kind of, it felt like a door opening, and I looked at it that it would give me the opportunity. I knew when I left the PD's office and I wasn't vested with the state, I thought sometime down the road, before I retire, I'll probably do something in public service, and I enjoyed it, the opportunity to be vested, and I thought, okay, it came up then, and I took it, and I had no idea how much I would enjoy it until I was there. But I never would have applied for the position had I not done contract mediating for them, because I wouldn't have known what it was like. I wouldn't have taken that leap, and I was kind of lured in unintentionally by having that opportunity to do contract mediating and see the cases that you can handle, the help that you can provide to those litigants. So that's how it came, and it's been an area that I wouldn't have anticipated in law school, that I would have been a mediator, didn't do mediation law school classes, and love it, absolutely love it. And that's the great thing about the law practice, is that you can just go into all different areas. Like when I started law school, I wasn't thinking of being a public defender, and I loved it. I mean, got you in the courtroom, got you doing trial work. I loved it. I love private practice. And that's the great thing about the law. And that's the same thing being a judge in this circuit. I think our judges, in a good way, rotate quite a bit compared to other areas I've been in, and maybe just because the other areas were smaller. And you've got to be prepared to go into any area, and whether it's criminal or probate or family, to be prepared to do that. I think my background allows that.
Are there judges that you have worked closely with that you admire, that you would seek out as a mentor, that you would sort of model yourself after if you were to become a judge?
I would say right now I like Judge Don Nichols for various reasons. When I was in private practice, we actually several times on the same case in various formats we had full settlement through mediation. Years later on modification, we went to a full trial on it, and it was, even though it was obviously contested, we went to trial and had to have a resolution there. Still very professional to deal with. Then as a mediator, actually had her, in one of my cases as a mediator, and seeing that when I prepare for cases, I'm looking through them for. So seeing the rulings that come out of her courtroom from family law. I think she has a great grasp on it. So from the family bench, definitely Judge Nichols would be a great person to model myself off. I had loved Judge McFerrin-Smith. I know he's retired now, but doing probate work before him, I would learn things before him, and I'd go down in Seminole County and do some probate work there, and they would be like, oh no, you don't need to file that. I'm like, oh no, trust me, there is a rule that says I have to file that, but they just, much more informal, but no, that's the rule, you gotta file it, and he kept you on task with that, and that's great. You know what I mean? I had an attorney from South Florida when I was in private practice. He called me and he's like, yeah, I took a probate case for a friend up in Volusia. I'm like, no, you don't dabble in probate when you're in Volusia County. You got to be fully committed. This is not, So I appeared for him for a hearing because he didn't realize, like, no, those hearings come up often. You need to be there, but it was good training as a probate attorney to appear before a judge who was meticulous, but had no problem guiding you. Like he said when it's not adversarial, it's like that's his role. He's not there to, punish or sanction either side. Just want to make sure that probate case gets resolved appropriately. It was good training. Like I said, it made me probably better, more skilled in other counties, even if they didn't necessarily appreciate the skill I had. But you had to be totally on top of your procedures there.
Susan, thank you. I'm sorry, go ahead.
You have, I know your schedule is booked up during the day. You have what?
3 days.
3 a day?
A 3 day in Volusia and Flagler, 2 a day because there's more driving up there.
Do you have, and I know mediation, you do the agreement and it's all right there. Do you have other duties that go along with your position there? I mean, like before you get to work or before you start mediation and afterwards?
There's administrative functions that we've had a change in court supervisors. Bob Stern had retired a few months ago. And he used to remind me, he said, the administrative part of your job is just as important. And although, attorneys only see me doing the mediation, part of the administrative part, we have to report in, and it may seem silly, but we report in once a month to our supervisor who sends it up to the Office of State Court Administration on the number of mediations we hold and the numbers that are referred. Not the resolution, they're not asking, there's just number, and basically to see, how busy is the program. Because when I started in 2011 for 4 counties and roughly 1 million people in those 4 counties, they had 2 mediators. And I was booking out, after a while, I was booking out almost 3 months. And for people who do family law, you don't want to wait 3 months to do a mediation, but we were that busy in Volusia County. And so because of those statistics that we were compiling, it gave the administrator something to kind of show the state of saying, hey, we are needing funding for an additional position. And so the statistics that were coming out of our circuit that, we got funding for an additional mediator who now, helps. That's why I'm in DeLand, and now I'm booking out more like 4 weeks or so, which is a much more reasonable time. And then rotate up into Flagler. So the mediator who was there now gets to, spend a few less days there and a few more days over in St. John's and Putnam. So that part of administrative. And then just the scheduling. Scheduling does not occur during court. That's me. So I know sometimes people are like, we can't get a hold of you. It's because when you're in my office, I'm not answering my phone because I'm in mediation and I try to focus that time there. So it's, it's a very efficient, streamlined program in the circuit. There's no fluff with our mediation program. So there's the administrative part of that.
Susan, thank you for coming in. We'll let you know by the end of the day.
All right, thank you.
Thank you.
And I appreciate Cobb Cole having this facility open. I know it's so hard to get everyone to have their schedule available for the day.